Can you all hear me? Good. Thank you. Thank you. Good morning. Thank you for being here. My name is Juscelino Colares, and I teach trade, civil procedure, conflict of laws, and regulatory law courses here at CASE. Before I give you some brief opening remarks, allow me to introduce our distinguished guests, experts on trade, foreign policy, national security, and public international law. Our first speaker will be Richard Cunningham, or Dick Cunningham, as everyone who knows him even for 2 minutes knows. He's a great guy. He's an international trade partner at Sept and Johnson LLP in D.C. And along with Bob, I would say that along with Bob Lighthizer, the current USTR, United States Trade Representative, I need to remind myself that not everybody knows what these acronyms are. And so along with Bob Lighthizer and Alan Wolf, currently Deputy Director of the WTO, he has been one of the top three international trade lawyers in this country the past 3 decades. Dick is not only a leading trade lawyer and policy advisor with vast experience and deep expertise, but he's also a great guy, widely liked both in D.C. and in Cleveland. Welcome, Dick.
Thank you.
Second speaker will be Lawrence Herman. Larry is a principal at Herman and Associates and senior fellow at the C.D. Howe Institute, one of the top Canadian think tanks. He's a former diplomat and also has vast experience on trade and economic matters. Currently, he's also chair of the Toronto Summer Music Festival. Very interested in that, by the way, Larry. And a member of the Council for Business and the Arts, a nonprofit corporation advocating closer ties between Canadian performing arts organizations and the private sector. Please, let's welcome Larry. Our third speaker will be Jamil Jaffer.
We switch places.
Oh,
we're trying to trick you.
Okay,
No,
so
no,
that's fine.
you're
That's
fine.
perfectly fine. Do you want to go?
I'm happy to go whenever you.
No.
No.
Okay,
as
so
long as they don't call me
We just switch seats.
oh, just okay. Not order.
Not order.
Okay, gotcha. So Professor Jaffer currently serves as the founder of the National Security Institute. He's an adjunct professor and director of the National Security Law and Policy Program at the Antonin Scalia Law School at George Mason University. Jamil is also, Professor Jaffer is also a visiting fellow at the Hoover Institution and recently served as a clerk to Justice Neil M. Gorsuch. Professor Jaffer has a rich, diverse experience in the national security and foreign policy domain, which include leading the work in the development of the Iran Nuclear Agreement Review Act and 2 sanctions laws against Russia for its intervention in Ukraine. He served in the Bush II White House as an associate counsel to the president, handling Defense Department, State Department, and intelligence community matters. So you see that despite his young age, he's accomplished much. Please welcome Professor Jaffer. And our final but not least speaker is Eugene Kontorovich. Professor Kontorovich is professor of law at Antonin Scalia Law School. He specializes in constitutional law, federal courts, and public international law. He's one of the world's preeminent experts on universal jurisdiction in maritime piracy, as well as international law in the Arab-Israel conflict. The co-editor of Economic Analysis of International Law, recently published with Edward Elgar. Professor Kontorovich is widely published and recognized in both academic and media circles. A double graduate of the University of Chicago, undergrad and law school, Professor Kontorovich clerked for the Honorable Richard Posner, United States Court of Appeals for the Seventh Circuit. He's now retired. And Professor Kontorovich was honored with the fellowship at the Institute for Advanced Study in Princeton in 2011, and also by the Federalist Society prestigious Bader Award given annually to a young scholar under 40 for outstanding scholarship and teaching. Please welcome Professor Kontorovich. Again, my name is Juscelino Colares. I had to weigh my role today as a chair for this panel against my very strong interest in saying something about trade. Of course, the guests are the center of the attention here. Specifically, I wanted to say something about the Trump administration's efforts in renegotiating trade agreements. So I'll make very brief remarks about President Trump and Ambassador Lighthizer preferred tools for renegotiating or, if necessary, withdrawing from agreements, particularly the deployment of Section 232, also known as the national security tariffs on aluminum and steel to imports from WTO members, and Section 301 tariffs against China's intellectual property / forced IP transfer practices. These are clearly these two tools that have been used, quite controversial, but they're clearly levers to renegotiate trade deals we negotiated about 2.5 decades ago. For those interested, and with China less so. For those interested in a much deeper discussion on trade and customs issues, I'm organizing a practitioner-focused conference here in this very room, Friday, October 26th, where these and other major issues will be discussed with lawyers from DC, New York, Chicago, LA, and 2 international United States Court of International Trade judges. For now, let me just, of course, the judges will only talk about law, not policy. For now, let me just state that my brief effort here is to be as descriptively accurate as possible on what's happening on trade, leaving to you the decision of of whether any of this makes sense or not. From a 30,000-foot perspective, if there's disagreement on policy among the members of our panel and audience, there's a great point of convergence. Politics and the results of elections explain much of what has happened since the election of Donald J. Trump. What one sees in trade, national security, and foreign policy, the topics our panelists will discuss, is the interface of different political choices and electoral promises with a changing international landscape. The question is not whether policy is good or is not only whether policy is good or bad, and there 2 reasonable persons can absolutely disagree, but whether the president is enabled by our Constitution, but also whether the president is enabled by the Constitution and statutes, by our Constitution and delegated power under these statutes, to conduct foreign relations the way he and his representatives have. Let me just briefly illustrate with trade, and I'll be very brief. The U.S. has liberalized the most among all countries. Average tariffs on dutiable goods, 4.5%. Our average tariffs on all goods, including dutiable and duty-free goods, is less than 2%, even less than 1.9%. Yet U.S. goods face higher tariffs and many non-tariff barriers to entry abroad. Obviously, free trade is the best policy, and the United States stands to gain the most from further liberalization because it has liberalized the most. Yet, for a president who was elected, that's okay. Yet, for a president who was elected, among other things, on a promise to review all trade agreements, that is precisely the difficulty. To be clear, he faces the major problem. A further round of tariff reduction simply cannot work the magic it used to. If you're going from less than 2% to 0, what is the incentive for other countries to want to bring their tariffs, even at 5%, but by 5%, to reduce them? And there are 2 other major problems as well. The biggest problem, obviously, is China. China's refusal to adopt free market and trade liberalizing reforms, its forced tech transfers, and use of its upsurge in economic might to challenge American power and primacy require a political response, not only a trade response. The legal framework, another problem, the legal framework, WTO, NAFTA, designed to promote and enhance international commerce, has been weak and is not equipped to address mercantilist policies and practices that either circumvent it or are beyond its scope. Thus, if limited U.S. leverage meant dealing with these systemic problems would be very difficult, should we be surprised that, rhetoric aside, a property developer turned president who sees things transactionally, has a zealous lawyer in Lighthizer, and free access to much statutorily delegated power, and exclusive foreign relations power under the Constitution, would not have used the power he has? Of course, moving pieces this large disrupts global supply chains that took years and a good deal of regulatory predictability to set up. Similarly, changing policy with regard to addressing North Korea, Iran, the rise of China as a major power, the Israel-Arab conflict, and the Middle East in general, viewed from a very high level, necessarily requires us to consider the use of presidential power and what our constitutional system allows. I believe we are uniquely fortunate to have these experts enlighten us today, and I thank them for being here. Thank you.
Okay, thanks, Juscelino. In the English comedy series Monty Python's Flying Circus, every episode began with John Cleese sitting at an anchorman's desk, and he would look up at the camera and he would say, "And now for something completely different." In the Trump administration, we in Washington wake up with that phrase in our mind every single day. And one clear aspect of that is in how things are done with respect to trade agreements, threats to withdraw from trade agreements, and the sort. That's what this panel is all about, and it's a particularly significant subject. And drawing on what Juscelino said, I submit to you it's a mistake to look at the Trump administration's trade agreement policy, their threats to withdraw from trade agreements, their desire to renegotiate trade agreements in isolation. Rather, one must look at the trade agreement negotiations and the unilateral import restrictions and other leverage devices together, and look at try not to look at either one as an end in itself, but look at both of them as ends that are, as means that are used together by this administration to get other specific goals accomplished. The gentleman from Timken talked about the Section 232 provisions on steel, and I would suggest to you that those started out as protection of the steel industry, and now they're mostly used as leverage in negotiations in ways we'll talk about in just a moment. You have to look at these things together. This is a deal-making transactional administration. People say that all the time. In this area, more than any other, that is true. And for Donald Trump, and you can get this from reading The Art of the Deal, leverage is the key to negotiating success. He wants to create leverage. He does so by unilateral import restrictions. He does so by other methods. Also, he uses trade agreements and threats to withdraw as leverage to negotiate other things. And sometimes trade is used as leverage in totally unrelated objectives. It can be as specific as trying to get an American pastor out of Turkish prison. Now, before discussing how some of this has worked in practice, let's be clear about the two principal policy goals of the Trump administration in trade. First, eliminate the U.S. merchandise trade deficits with specific countries. Second, restore the U.S. manufacturing sector and bring back to the U.S. production that American countries have established offshore. Global value chains that Juscelino referred to are now a bad word in Washington. And underlying these two goals is a conviction that foreign governments and exporters do not play fair in their dealings with the United States in trade. That was a theme throughout the Trump administration campaign. It is a view thoroughly held by people like Bob Lighthizer, by people like Peter Navarro, who is the Trade and Industrial Policy Advisor in the White House, and by Wilbur Ross, the Secretary of Commerce. So let's look briefly at how all of this is working out in practice, and I begin with import limitations as leverage. In this regard, the administration has turned, as Juscelino said, to two statutes that have been dormant for decades, dormant because we, as to one, we essentially gave up the ability to use import restrictions in 301 proceedings in the Uruguay round, and as to the other, we have had a very restrictive view historically of Section 232 on national security. Why these statutes instead of the anti-dumping, countervailing duty, or safeguard statutes? I submit there are two reasons. First, these two statutes give to the executive almost total flexibility to devise the nature of the import restriction measure, to change it as time goes by, to do pretty much anything they want, and therefore it is an immensely flexible tool to use as leverage to achieve other goals. And secondly, a belief by this administration that no challenge can be brought either in U.S. courts, and they're probably right about that because these are discretionary presidential decisions, and normally we do not allow appeals of the substance of a presidential discretionary decision in U.S. courts, nor, in the view of this administration, are these challengeable in the World Trade Organization. And if we have some time, I can talk about that. That will become a major issue. It is being challenged. That view is being challenged by Canada, by the European Union, by China, and everybody else in the world. And in several years, unfortunately a little late to do any good, that will be resolved, and I suspect the U.S. will lose that, but we shall see. These import restriction measures can be powerful leverage tools, and you can see that from how aggressively administration is using them. Section 232 began with aluminum at 10% and steel at 25% tariffs against all exporting countries, against at least one country, Turkey. President Trump, bingo, doubled them when he wanted to get the pastor out of jail in Turkey. And there is a threat, and this is something of a nuclear weapon in trade, because it is the biggest category of merchandise trade in the world, a threat of 25% or higher tariffs under Section 232 on automobiles. Look at how they're using Section 301, tariff against China in response to the unfair practices that Juscelino talked about, including, in addition to the ones he mentioned, the subsidies that are going into what is perhaps China's biggest industrial policy move, the Made in China 2025 program, starting out with tariffs on 50 billion Chinese imports. Within a week or two, you're going to have 200 billion in Chinese imports, and the president specifically said he's going to go to $267 billion. Let me talk how these are going to be used, talk briefly about how these are being used in NAFTA and China. NAFTA, you recall, is the worst trade agreement ever negotiated. Why is that? Because we have a trade deficit, mostly with Mexico, and a movement of production away from the United States. Again, mostly in Mexico, particularly to autos. How do you get leverage? Well, first, you threaten to withdraw and reluctantly agree to renegotiate. Second, you impose Section 232 tariffs globally on imports of steel and aluminum, but say you will consider exemption of Mexico and Canada to comply with U.S. NAFTA demands. And then you find that those aren't really working. You're not getting your demands in NAFTA satisfied, and so you go to auto imports. And that gives you massive leverage on Mexico. And Mexico comes to the table, and you do a deal in principle with Mexico. We'll see how much of a deal that really is pretty soon. And that, in turn, puts huge pressure on Canada. They'll have until September 30, and then, as Trump says all the time, we'll see what happens. Now let's look at China. We don't have an agreement, but we want one. The game here is to prevent China from gaining ground on us in the industries of the future, like artificial intelligence, autonomous vehicles, things like that. So we start with the 301 case. We progressively ratchet up the pressure to get China to negotiate a deal. But while China is willing to negotiate on amounts of trade, we'll buy more soybeans, we'll buy more natural gas, they're not willing to negotiate on structural issues, because these are very fundamental to how China sees its role in the world and the role of its economy in the future. So on both NAFTA and China, I submit we're now approaching the moment of truth as to negotiation by leverage. The U.S. leverage is basically negotiation by threat. What do you do if your threat doesn't get the other party to capitulate sufficiently? Are you really prepared to go through with your threatened action? As to NAFTA, is the U.S. really prepared to withdraw from NAFTA, do a Mexico-only deal, and impose Section 232 auto tariffs on Canada? Remember, we haven't yet withdrawn from any trade agreement. We withdrew from 2 negotiations in progress, TPP and TTIP. We have not yet withdrawn from any agreement. We backed away from withdrawing from the U.S.-Korea agreement. We have not yet withdrawn from NAFTA. As to China, are we really prepared to impose stiff Section 301 tariffs on all imports from China? That's where you would be in that next step I said, the 267 billion. Are we prepared for the amount of retaliation that would follow? And we have similar put up or shut up moments coming with respect to the EU and with respect to the WTO, which we can talk about if we have some time. My own view is that Trump and his team don't know the answer to these questions. And the moral that I draw from all this is that leverage is all well and good, but you have to think it through to the end game, and I don't think these guys have done that.
Ray Herman.
Thank you very much. First of all, as the only Canadian at this event, I want to say how pleased I am to be back at this wonderful law school at Case. I've been coming here since 1986 as a participant in the Canada-U.S. Law Institute, and it's always a pleasure to be here, and it's always a pleasure to be in the same room as Michael Scharf, and I commend him and the other members of the faculty at this fantastic law school for putting this program together. So, Michael, thank you for bringing me back to Case and giving me an opportunity to speak.
And for being the best law school rock band on the planet.
Now, I have to take exception to one point that my friend Dick Cunningham made. Actually, the only trade agreement that the U.S. has withdrawn from was a trade agreement with Canada. Most Americans don't know that. The first trade agreement the United States ever entered into was a trade agreement with Canada, the 1854 Reciprocity Treaty. Now, it was a treaty. Canada, at that point in time, was part of the United Kingdom, but it was a treaty, a trade agreement between the United States and Great Britain, dealing with trade between the U.S. and Canada. It was mostly concerning the fisheries and other resources, but it was the first trade agreement the United States ever entered into with any other country, the 1854 Reciprocity Treaty. Interestingly, for purposes of our discussion and to address what Dick Cunningham talked about, the 1854 Reciprocity Treaty was terminated in 1866. The only trade agreement the U.S. has ever terminated was that trade agreement with Canada. And for our purposes, what is equally interesting is that the president, who at the time was President Johnson, you know, he succeeded when Lincoln was assassinated, Johnson had to get the approval of Congress to abrogate the Reciprocity Treaty. It went to the Congress. Now, that's an issue, of course, that concerns Americans. It's an internal constitutional issue, the role of Congress in terminating treaties. But I just raised that as an interesting historic point. Another interesting point, and I'm not going to dwell on this, it's in my paper. Did you know that the United States and Canada negotiated a second reciprocity treaty in 1911? That reciprocity treaty of 1911 was sent by President Taft to the Congress for approval, and Congress approved it. It was Canada in 1911 that rejected reciprocity with the United States. Interesting. So look where we are today. I want to talk a little bit about treaty withdrawal because that's the subject of our panel, and focus on the NAFTA. It's a very confusing situation, as Dick Cunningham has pointed out. Look where we are today, and maybe those of you who know more than I do about public international law and the law of treaties can help me out in this regard. Negotiations took place, have been taking place among the three countries, but on the 27th of August, the United States and Mexico announced that they achieved a preliminary agreement in principle. And that was notified by the President to the Congress under Trade Promotion Authority. I found it interesting, and this is important for purposes of the discussion, that the agreement with Mexico, not with Canada, but with Mexico, was an agreement in principle entitled Modernizing the NAFTA to be a 21st Century Trade Agreement. So the President notifies the Congress of his intent to sign an agreement that modernizes the NAFTA. Canada was not party to that preliminary agreement. It was between Mexico and the United States. And Mr. Trump said if Canada wants to sign on, they can, but if not, we're going forward with this U.S.-Mexico agreement. But it's an agreement to modernize the NAFTA. I assume it means that on the 1st of December, in accordance with Trade Promotion Authority, if Canada is not party to this at that time, President Trump and President Peña Nieto will sign an agreement to modernize the NAFTA. How do you modernize a trilateral agreement if the third party isn't there? I don't know what the answer is to that. There's nothing in the NAFTA that in any way indicates that 2 out of 3 can modernize a tripartite agreement. I think it's very unclear what this U.S.-Mexico agreement means. The other question is this, and this is for discussion later. NAFTA, Article 2205, says that any party to the NAFTA may withdraw from the treaty on 6 months' notice to the other parties. That's all it says. It doesn't say what happens after that. And there's nothing in the Vienna Convention on the Law of Treaties, those of you who study public international law will know this, that clarifies the situation. What it means is that if notification under Article 2205 is provided, it doesn't follow that the country providing that notification actually has to withdraw. It's just a notification of the intention to withdraw after 6 months. So the question is this: if Canada and the U.S. don't solve their differences, and negotiations, as you know, are going on now, they haven't achieved agreement. At least Canada and the United States have not achieved agreement. If the United States signs a NAFTA modernization agreement without Canada and presents that to the Congress, does that not then mean at the same time that the United States provides its notice of intent to withdraw from the NAFTA, or not? Does Mexico then provide its notice of intent to withdraw from the NAFTA, or not? If they do that, how do you modernize a NAFTA where both countries have already given their intention to withdraw from the NAFTA? If, on the other hand, the U.S. and Mexico enter into a separate bilateral agreement, a trade agreement, outside of the NAFTA, does that not also mean that the U.S. and Mexico have to withdraw from the NAFTA? Or could it provide simply that the U.S. and Mexico, between themselves, are parties to a bilateral trade agreement that, as between the U.S. and Mexico, succeeds the NAFTA, but doesn't terminate the NAFTA as between Mexico and Canada, or Mexico and the United States? Where does this lead us? I'd like to have some answers, and we can get to that in the discussion. What concerns me as a practicing lawyer is the lack of clarity in U.S. policy in respect of the NAFTA. I mean, we know, and Dick Cunningham is absolutely right, we know the objectives, the political objectives of this administration. But what is going to happen if we go forward without a U.S.-Canada agreement on NAFTA modernization, which seems to be where we're heading? The U.S. and Canada are deadlocked on some very key issues, and at the present time, there doesn't seem to be a clear route to resolving those. And so if the U.S. and Mexico proceed, all of the issues that I've just outlined will continue. And as I said, as a practicing lawyer, this causes a lot of uncertainty in international business. It impacts upon a whole range of industries, not only goods producing industries, but service industries and the whole financial community. You know, there are reports about the effect that this uncertainty is having on the markets. And that uncertainty, in my view, will be exacerbated significantly if on the 1st of December, the U.S. and Mexico sign an agreement without Canada. There will be no clarity to the trading arrangements among the three countries. So I'm going to leave it at that, and I'd like to have some answers, and maybe some people know where the clarity might be in all of this confusion.
So I thought I would talk a little bit, make a sort of a change from the international trade agreement conversations and talk a little bit more about the more classic international agreements, although the one I intend to talk to you about is hardly classic. And I want to talk about the Iran nuclear agreement that we reached in the Obama administration and that President Trump has since withdrawn from. So obviously, as you all know, President Trump during the campaign process made clear his intention, if elected, to withdraw from the Iran nuclear deal, his concerns about the deal, the scope, the nature of the deal, and for the first year of his administration, didn't in fact withdraw. Spent a lot of time discussing it, debating it internally, but continued to implement the sanctions relief that was put in place by the deal. And ultimately, when he did make the determination to withdraw, there was a tremendous amount of hand-wringing, concerns about the U.S.'s international standing, having pulled out of a major pact that included the P5 plus one, and obviously Iran. And so worth thinking, I think, about where this deal came from, the nature of the agreement itself. Was it a international accord as we think of these things, and if so, what type of international accord it was? What status did it have under law? And what did Congress's action that it took, that I was part of when I was at the Senate Foreign Relations Committee, what did Congress's role in that process have to do with the accord? Did it make it any more legal as a matter of domestic law or international law? What did the UN's actions have to do with that? So in 5 minutes or less, I'm going to try and roll that out for you. Then we'll turn to Eugene and we'll hear about the Paris Climate Accord, and then we can have a discussion about all of these issues, these international trade agreements, Iran and Paris altogether. So worth stepping back to the original negotiations with the Iranians even prior to that, which is to say that Congress had put in place a range of sanctions on Iran, both on its own as well as in cooperation with the president. So the president has broad authority under existing U.S. law to impose sanctions on a range of nations under the National Emergencies Act and under the International Economic Powers Act. The president has broad authority to impose sanctions once he determines and informs Congress of his intention to do so under those two statutes. So in the case of Iran, we had imposed both statutory sanctions. Congress, historically going back to the 1980s, following the takeover of Iran by Ayatollah Khomeini, and the president had, under his own authorities, under IEPA and NEA, imposed a variety of sanctions. So the situation that faced the Obama administration in the early 2011, 2012 timeframe was a set of sanctions that had been imposed on Iran, and a Congress that was interested in imposing even more sanctions. In particular, the particular crushing sanctions that were imposed on Iran in 2012, 2013, where Congress essentially imposed what are called second-party sanctions, wherein the U.S. said, if you decide to transact with Iran, and there were a variety of caveats about oil reductions and the like, but all that really matters was if you ultimately decide to go forward transacting with Iran and you haven't done certain things, the U.S. will cut you off of the U.S. banking system. And so what ended up happening was that a number of our trading partners, the Europeans in particular, were forced, under the dint of being cut off from the U.S. banking system, to cut ties with Iran or to reduce dramatically their oil imports from Iran in lieu of cutting off all financial ties. That put tremendous pressure on the Iranian economy. The way those sanctions came about is also worth noting, which is that the Europeans made very clear to the United States they were opposed to those sanctions. The Obama administration made very clear to Congress that they were opposed to those sanctions. And Congress demonstrated to both the Europeans and the Obama administration that they had a veto-proof majority in both houses to implement those sanctions, given Iran's behavior in the nuclear arena, as well as its international lawless activity in the region, its support for Hezbollah, and support for other terrorist groups in the region. And so, with these sanctions being imposed upon Iran, the Obama administration found itself in the enviable position of having a huge cudgel hanging over the head of Iran, which is to say, tremendous pressure on the economy. This led to secret negotiations in Oman for a while, negotiations that eventually came out in public and integrated the P5+1 in, and ultimately led to the Iran nuclear agreement, the Iran nuclear deal. What's interesting about the deal itself is that as we went through this process of negotiating, what became very clear over the course of the agreement was that the administration did not intend to enter into a treaty-type arrangement, which is to say an agreement that the administration determined was of the nature that it had to be submitted to Congress, to the Senate, for its advice and consent. Instead, the administration made clear over the course of the negotiations, both to Iran and to the Congress, that it intended to enter into some sort of another agreement. What that agreement was wasn't clear at the time, and it really didn't become clear until the very end of the process. And where the administration ended up was it ended up agreeing to a political agreement. In fact, it ended up with an agreement that was not signed by either party. It was simply a document that the parties agreed to implement. You might ask yourself, well, why would you end up there? Why not a treaty? Why not a binding agreement that's at least signed by the parties? And if, in fact, it's a non-binding political commitment, why all the Sturm und Drang about the fact that we pulled out of it in the Trump administration, knowing that this was simply a political commitment made by one administration, knowing that if elected, all the Republican candidates on the other side of the aisle had made clear they would withdraw from the agreement, and in particular, Donald Trump had been very aggressive, and when the surprise of his election happened, why anybody was surprised that we pulled out or that it happened in the way it did are important questions for us to consider and debate. So what did Congress do when it figured out that the president wasn't going to submit this agreement to Congress? And wasn't, in fact, what became clear over time was not only did the president not intend to submit it as a treaty, but that he didn't intend to even show the text of the deal to Congress whatsoever. Part of the problem was created by the fact that in the statutes that Congress had passed, it had provided for national security waivers, so that the president could remove sanctions, at least for some set period of time, and could do it repeatedly over and over again, simply by informing Congress ad infinitum. Now, Congress had never intended these national security waivers to be used in this manner, and nor had any prior president ever used national security waivers to implement long-term agreements with any other nation. But the authority, at least on the face of these statutes, was there. And so the president made clear to Congress, look, I've got the authority, if I want to waive these sanctions going forward. That's the relief Iran seeks. And for that, I'm going to enter into an agreement with them. You don't need to see it. You will get a chance to vote on it. That chance will come in a decade or so from now when it comes time to lift sanctions on Iran permanently, if in fact they've been in compliance with the deal. Well, of course, Congress did not take kindly to this notion that somehow they would not see the deal, they would not get a chance to vote on it, not be involved. But at the same time, given the political reality of the number of votes in the House and the Senate, there was no chance for Congress to effectively force the president to submit the deal to them as a treaty. They didn't have the votes to reject it out of hand or to remove the president's waiver authority. And the president having made clear that they could not, that they having known they couldn't withdraw funding for it, didn't have the votes to do that, and didn't have the votes to force the president, to remove the president's waiver authority, the president having made clear he intended to use it, Congress had to come up with an alternative tool, a tool that could obtain bipartisan majorities in both houses in order to get it past a potential presidential veto. Ultimately, the tool Congress decided to use was to remove the waiver temporarily from the president, to force the president during that period to submit the treaty, this agreement, this deal, this non-signed, non-binding political commitment to Congress. So Congress did remove the waiver temporarily. The president did ultimately submit the deal and sign this legislation because there were bipartisan veto-proof majorities in both houses. And ultimately, though, Congress applied the regular rules of order, saying that it could not, that the only way it could remove the president's authority to implement the deal was to pass a veto-proof resolution, which, of course, everyone knew it didn't have. And so the president knew he could get the deal through on his own authority, but that he'd be forced to submit it, and that Congress at least temporarily monkey with its authority. So where do we find ourselves today? We find ourselves in a place where the nuclear deal was put into place by President Obama under these conditions. We have President Trump elected, making clear that he intended to pull out. And now, having done so, the concerns of the international community are, well, we've withdrawn from an agreement that had almost universal consensus around the world. We've shown ourselves to be a bad actor, a participant in agreements that will welsh on. And worse, we put our allies in a terrible position because they're gonna try and break away from the deal and keep the deal in place without us. We've seen Secretary Kerry travel around the world, both to our allies and to Iran, in an effort to try and keep the deal in place. We've seen, however, Javier Solana, the former Secretary General of NATO, make clear just yesterday that, as we've always known, the Europeans could not, in fact, sustain staying in the deal without the United States, because, again, the pressure of the crushing sanctions being put into place would prevent them from doing so. So, a tough situation for us to be in, both politically in the international relations world and also economically for our allies. But at the end of the day, some tough questions about how Congress deals with agreements like this, how the president should deal with these agreements going forward, and where we go from here.
Good.
Over to you, Gene.
Okay, I'm going to talk about the authority of a president domestically and internationally to exit certain kinds of international agreements, using as my case study the Paris Climate Accords. And in particular, the question is about exiting agreements and what it takes to enter agreements, because an agreement that has not been entered doesn't need to be exited. And the Paris Climate Accords, other than being quite salient internationally, politically, has several interesting features that really mark up this issue in a way which I think also is going to be seen again going forward in other broad kinds of international treaties. Now, in particular, the question with the Paris Agreement. Paris Agreement is a large multilateral climate accord which President Obama entered into as what we would call a sole executive agreement. That is to say, he signed it and accepted it on behalf of the United States, using solely his authority as President of the United States without submitting it to the Senate as a treaty, and without any explicit congressional authorization. So first I'm going to lay out some of the differences, the issues between executive agreements and treaties, which is a long-standing issue in foreign relations law, and then explain how the Paris Accords have some features which make it particularly difficult or problematic to characterize as something that the president can enter into as a sole executive agreement. And these features are particularly interesting because they might also suggest ways in which we can actually think about more formally systemizing the test, which is currently quite unclear, for distinguishing between executive agreements and treaties. So treaties are the Rolls-Royce of constitutional international agreements. Article 2 provides that the president has the authority to make treaties with the advice and consent of the Senate, and this is the gold standard of international agreements. A treaty submitted to the Senate is an international agreement which binds America domestically. It's supreme over state law under the Supremacy Clause. Otherwise, in many ways, it has the status equivalent to law. It's a big deal. It is not the only way domestically that, even though it's the only way clearly spelled out, the only procedure clearly spelled out in the Constitution for entering into international agreements, it is not the only way the United States can enter into international agreements. And in particular, there are two other ways, or rather one other way with two flavors. One is, and these are ways in which, these are methods in which agreements are not submitted to the Senate. One, an intermediate form, is what is called congressional executive agreements, in which Congress legislates using its various competences over, for example, international trade, giving the president authority to negotiate agreements, and then the president has the flexibility to enter into these agreements as he sees fit. The issue with treaties is Senate ratification is cumbersome, is in many ways unrealistic to secure Senate ratification for all of the, let's say, day-to-day or minor international agreements and arrangements that the United States may have to make. And so the final version is what we call sole executive agreements. I'll just call them executive agreements for short. These are agreements which the United States enters into with other countries, which are not ratified, do not involve Congress at all. There is a history of these also, dating back certainly to the early republic. They are clearly the primary form of international agreement by number. The overwhelming majority of international agreements entered into by the United States are executive agreements. And they typically take their memoranda of understanding, status of forces agreements, and other kinds of, let's say, administrative day-to-day arrangements between countries. And they're very large in number. The Paris Agreement was entered into by President Obama as an executive agreement on his authority as executive. And the constitutional theory behind these, while not explicitly mentioned in the Constitution, is that the president has wide powers as commander-in-chief. He has wide powers over foreign relations, and his core constitutional powers as chief executive allow him, inter alia, as a necessary and proper conduit, to make certain kinds of international agreements that do not, let's say, rise to the level of treaty. So how does one tell if something is an executive agreement or a treaty? It makes a big difference, whether you have to get Senate advice and consent. And the answer is we know it if we see it, or we don't have a good answer. There is an answer that the State Department has developed called the Circular 175 procedure, and it's very much what some law professors would call second restatement of conflicts approach. That is to say, famously, the first restatement of conflicts of laws determined what law would apply by, like, where something happened. So that's very simple. The second restatement of conflicts of laws determines which law applies by an 8-part test, no part of which is particularly determinative, and that just means there's no answer. But law students love multi-part tests because they think they're determinate because everything gets a number and you can memorize them. Of course, they're actually the opposite of determinative. And the Circular 175 procedure has a list of, I believe, about 8 factors determining whether something should be treated as an executive agreement or a treaty. Amongst those are, let's say, the scope and magnitude of the subject matter of the agreement. How big a thing are we agreeing to? Past practice with regards to subsequent agreements, and factors like this. Usually it's not much of an issue. Usually things go to the right box, or at least are not too controversial. The Paris Agreement, because of its extremely large, both domestic and international salience, actually did raise some controversy as to whether it can be entered into as an executive agreement, and in which has great importance for what the procedure for exit are. Now, I would say the Paris Agreement has two kinds of features, which make it very different from almost all, if not all, past executive agreements. And I want to say, I know I'm in a very difficult position here. I'm the last speaker before lunch. So I'm going to both keep this and to keep the attention of the law students. I want to say, as I finish up here, I might have some suggestions for what might be potentially interesting or useful research projects for anyone who has not written a comment yet. So it will pay to listen, potentially. So these two features, one directly relates to the actual exit provisions of the Paris Agreement itself. And the second relates to the multilateral structure of the Paris Agreement. So the Paris Agreement has, like many treaties, a clause about the terms of withdrawal from the treaty itself. Not all treaties have these provisions, but they're quite common. And it provides for, from the time it comes into force, essentially a 4-year mandatory non-withdrawal period. You cannot withdraw from the treaty for the first 4 years of its existence. It's really 3 + 1. You can only announce your withdrawal after the first 3 years of the treaty, and then you have to wait another year. So there are 4 years at the outset at which a country that joins this arrangement cannot exit. That raises, on a theoretical level, I would say on a constitutional level, serious questions about whether it can be entered into as an executive agreement, because the entire assumption so far about executive agreements has been that they're okay because easy come, easy go. They're like executive orders. There's been some debate about the president's ability to cancel some of those also, but the idea is that one president can sign them pretty easily and casually, the next president can unsign them, and so the degree of deliberation and consideration is much smaller because they are temporary in nature. They are based on the president's authority, and thus a subsequent successor can override them. Indeed, I was surprised to learn when researching this paper, in the early 20th century, there was a widespread view that executive agreements don't even bind subsequent presidents unless explicitly reaffirmed. That was the view of Secretary of State Simpson. That was the view of President Roosevelt. That's not the dominant view, but it has always been part of the concept of executive agreements that they are limited in their binding power in that a subsequent executive can get out of them easily.
What if laws have been passed to implement the nature of the executive agreement? What if Congress has implemented laws?
We'll get to laws, hopefully. So the laws are laws and executive agreements are executive agreements. Obviously, there's a process for undoing laws. That's called legislation. But this is the question about exiting these kind of agreements. So the question is, does a president have the authority to enter into, as an executive, an agreement, something that might have a very unusual delay clause? And it's at least conceptually difficult. We know in the case of the Paris Agreement, the 4-year time period was not chosen accidentally. That is to say, it was made deliberately to greatly limit a successor's ability to withdraw from it in what happens to be the duration of a U.S. presidential term. As it happens, President Trump will have like a month and a half at the back end in which the U.S. can be out of the agreement. That is also rather a matter of fortuity because the Paris Agreement came into effect earlier than expected because it got the necessary number of ratifications more quickly. It could have left the president even less time. So that's at least a conceptual problem given the theory of executive agreements. Now let's look at the practice of executive agreements, which is one of the things the Article 170, the Circular 175 procedure tells us to look at. So I was curious to find out, are there agreements with such long delay periods? Now, for treaties, for things that the United States accepts as a treaty, withdrawal periods vary. The 4 years is an extremely long withdrawal period for a treaty, but not unheard of for treaties. So, for example, bilateral investment agreements have 10-year withdrawal agreements. So it's very long. The default suggested by the Vienna Convention is 1 year. So it's unusual for treaties, but not unheard of. But what about things that aren't entered into by the United States as treaties? What about things that are entered into as executive agreements? So I looked into this using a few different databases of executive agreements. My research has been somewhat limited because between 1925 and 1946, I want to say, the State Department specifically published executive agreements entered into by the United States in a separate collection called Executive Agreements. But after that, the State Department publication of international agreements, treaties in force, lumps together every kind of international agreement that the United States enters into and does not really differentiate them. So you would have to read all through all of the many, many thousands of agreements and then see how they were ratified, see how they were accepted to figure out what is an executive agreement. This is a general problem many researchers have for looking into this. So what I did is I looked at all of the executive agreements in the original executive agreement series, 25 to 46, and then I picked several years, 4 different years in recent times, and had some law students, I must admit, identify the executive agreements out of the list of treaties, international agreements adopted by that in those years, and figure out what the withdrawal periods were, if any. So it turns out that 4 years is just literally off the charts. There seems to be absolutely no precedent for it. The average withdrawal period is a bit over 6 months. In the first period, 6 months was the norm, and also somewhat at the high end because many had much shorter periods, like 0. And 1 year seems to be the absolute longest withdrawal period in any executive agreements the United States has entered into. So at least judging by the Circular 175 kind of methodology, which I'm not a fan of because I'm a formalist and it's an all things considered thing, this is a very sharp departure from past practice under executive agreements, and also one that raises core conceptual difficulties. Now, again, the problem is, how do you draw a bright line? So I'm a formalist, so I care about these things. If 1 year is okay, what about a year and a day? What about 2 years? And I'm not sure there's any good answers here. This is certainly not a kind of thing where there will be line drawing, because lines are drawn by courts, and this is obviously a political question. But certainly a 4-year term, or maybe even anything longer than a 1-year term, raises significant constitutional questions about whether the United States can actually obligate itself by means, whether the president can obligate the United States by means of an executive agreement. But now let me turn to the multilateral nature of the treaty. The overwhelming number of executive agreements are bilateral. They are purely, and they deal with relations just between two countries. Paris Agreement is obviously far from that. There's a theoretical basis for this distinction. It's well recognized that multilateral treaties correlate greatly with the importance and depth of the subject and obligation. This is why multilateral treaties have a very different success rate in Senate ratification than bilateral treaties, much harder to get passed, because they are a bigger deal. So similarly, took a look at executive agreements in this data set. It does not appear that there have been any significant number of multilateral executive agreements. There are a few that have been mentioned, but they do seem to mostly be congressional executive agreements, such as NAFTA or the NATO Status of Forces Agreement. Again, I've worked with a small sample, and a great idea for a law student would be to take one of these two subjects, either duration or multilateral nature, and really drill down, take lots of years, take lots of agreements, and see what we have. Now, formally though, but you can say, what's the difference between a bilateral treaty? Let's say there's a trilateral treaty, some kind of trilateral maritime cooperation agreement, regional agreement. What's the difference between 2 and 3 and Paris? And there's a really clear conceptual difference here. There is a kind of treaty known in international law to be a treaty that holds itself out to membership by any country. And these treaties generally are more ambitious in scope, and they are seen by many proponents of a rules-based international order as the building blocks of a global international constitutional order. The Paris Agreement is very much one of those, and one can, I think, clearly distinguish between sort of N+1 treaties and treaties whose goal is universal accession. A correlate of that is the Secretary General makes himself available as a depository for certain kinds of treaties. Those treaties are multilateral treaties of particular importance. And the Paris Agreement has as depository the UN Secretary General. So all these things sharply distinguish it from past practice of executive agreements, which suggests that it could not properly be entered into. As such, these are all signs that it's a treaty. Let me end with the following observation. A final corroborating factor, to which I don't want to attach domestic constitutional significance, but a sign that we may be onto something, that it looks like a treaty, smells like a treaty, talks like a treaty, maybe it's a treaty, is that as far as I have been able to determine, and again I've not been fully comprehensive because it's quite hard to research this, and our papers here are short, all the other state parties to the Paris Agreement have treated it as an international treaty for purposes of their domestic ratification processes, whatever they are. Some countries don't require much. Some countries require more. In countries with US-type constitutions that require transmitting it for ratification or at least review by the parliament, every country has treated it as such an agreement. So the American exceptionalism in regards to the Paris Climate Treaty is not on the exit stage, it's on the entry stage, because the United States is the only country that the president went it alone and entered into the treaty on his sole authority without consent of the parliament, which suggests, on the question that Jamil mentioned earlier, what this will do to our international reputation. It's very hard to say that countries would see this as some kind of sign of backsliding or weakening of international commitments by the United States, because countries that have themselves felt compelled to go through their domestic ratification processes are in a difficult position to say that the United States should not have, and that the United States then treating this as an easily exitable agreement should be in a different position. Thank you so much.
Thank you very much, Eugene. before we move to questions to the audience, we have to be done by 12:30, and we don't want to be between you and your lunch. So let's be brief. I'm just gonna try to answer and make a brief comment on Larry Herman's question about what happens and if President Trump, per his question, attempts to withdraw the United States from NAFTA. You're absolutely right, Larry. The Article 2205 of the NAFTA provides that the United States may provide notice to withdraw NAFTA within 6 months. It doesn't say what happens after. Typically, what has happened is, or what happens is once that is done, that the United States will interpret that it's basically no longer obligated, or it would be no longer obligated under NAFTA, for the commitments it made under NAFTA. Now, to answer this very cleanly, I have to kind of keep your eyes on one particular thing. It's what is Congress's alternative if President Trump goes that way and basically does what he did with Iran, and the other parties, which means pull the trigger. And I would highly advise anybody not to play poker, not necessarily with the best player, but with the player that has the most chips by a lot. And Trump does have the most chips, and by a lot, which means even if you have the better hand and you feel he's bluffing and he's not that good of a player, I'll give you all that. He's got so many chips that all it takes is for you to be wrong once and you're done. So that's the best analogy I found to the context. So what is the alternative? What would be the alternative for Congress to do anything about this? Basically, going back to our constitutional structure, Article 1, Congress has the power to regulate commerce. There are 3 commerce clauses: Foreign Commerce Clause, Indian Commerce Clause, and the Standard Commerce Clause we study in con law in law school. The foreign commerce, basically the foreign commerce means that Congress and only Congress can regulate foreign commerce, can provide laws on foreign commerce, which means that for Congress, for anything to be done on trade in the United States and for the agencies to respond to anything having to do or impacting trade, Congress has to authorize that. That's absolutely clear under Article 1. The problem is that Article 2, Section 1 establishes that the power, the executive power of the United States shall be vested in the President of the United States, and Section 2 establishes the President's foreign relations power, basically establishing the President as the presidential primacy on foreign affairs. This is all non-controversial. So the President basically is the only person that can appear on behalf of the United States abroad. It's the President of the United States represents the United States. So the question is, definitely the President can withdraw from NAFTA. And the question is, what would Congress do? Well, Congress, because it has the commerce power, could easily, pass a statute. The question for Congress would then be, do you have a veto-proof statute? Because under our system, we also have, 2 requirements for legislation: bicameralism and presentment, right? So you would have to pass both houses. Simple majorities will do, so like a NAFTA fix through legislation. But then you would have to present that to the President, who basically can or could veto it. So long as Congress has a veto-proof majority, is it 2/3?
60 votes? 60, I think. 60 in the Senate. 60 in the Senate.
60 in the Senate, and I would say 60% in the House. I don't have the right numbers, but we can look that up later. So long as Congress feels confident it has that, then Congress can absolutely do what it pleases, because it does have the power to regulate commerce. The problem is if it doesn't, right? Because it still needs to negotiate with other countries, because it can't negotiate on behalf of the United States. And then we start running up into the problems that Professor Kontorovich here explained. All these leaders, when they signed the Paris Agreement, they all negotiated, they all brought these agreements back with the intent to get approval under their own constitutional systems, which under the U.S. system would mean the President would bring it back and get it approved. The President at the time, President Obama, knew he could not get approval, and he did the Presidential Executive Agreement, which, it has, what's good for the goose is good for the gander. It's easy to pass, but on the other hand, it's easy to do away with. So the problem is, if President Trump does this, and I believe that he will do this, if Canada does not negotiate, or if the position is not there, it puts Congress in a very difficult position. Unless you have those 60% votes, that supermajority, Congress' hands will be tied. Anyway, that's just my tentative answer to your structural question about our system.
Yeah, if the president signs a revised NAFTA or a bilateral treaty agreement with Mexico, and by the way, there's a difference between what the U.S. might consider internally for constitutional reasons a treaty and what the international community regards as a treaty. A treaty under public international law is an agreement between states intended to be binding. Whether it's considered an executive agreement under U.S. law, it may not be the test if it's clearly on its face intended to be binding. But the president would have to submit a bill to Congress to de-implement the NAFTA. Congress has passed the NAFTA Implementation Act, and there would have to be U.S. law passed by Congress to de-implement the NAFTA. Congress could refuse to pass that legislation, in which case the NAFTA would remain binding on the United States because there would be laws of the United States that implemented the NAFTA unrevised.
Let me add two complicating factors to this. One is that if you look at a scenario in which the president goes to Congress with a bilateral U.S.-Mexico treaty, it is not clear that he has trade promotion authority to do that.
That's a separate question.
And that doesn't mean he couldn't submit it. It just means that it doesn't have the unamendable ratification process, which is a massive problem for it. The second complicating factor is, if he does withdraw from NAFTA as to Canada, or withdraw from NAFTA generally, there is a view that the U.S.-Canada Free Trade Agreement remains in effect at that point. That is important for a number of reasons, not least of which is that a massive bone of contention between the U.S. and Canada is the Chapter 19 process for appeal of U.S. anti-dumping, countervailing duty, and other trade decisions to a trinational panel. In Canada, U.S.-Canada, it was appealable to a binational panel. Indeed, that was a major sticking point for Canada in that negotiation. So Trump probably would have to withdraw from U.S.-Canada Free Trade Agreement as well as from the NAFTA, and that raises other questions. To say that we're going into terra incognita is an oversimplification of the process.
I just should add that under the original Free Trade Agreement, 1988, entered in force in 1989, the binational panel system had 5 years of life. It was to terminate after 5 years, and it almost reached that point before it was inserted into the NAFTA and given perpetual, if you can put it that way, perpetual continuity. So if you reverted to the FTA, the original Free Trade Agreement, arguably the binational panel system will only have a short lifespan to continue. So that would resolve a problem that Mr. Lighthizer has with binational panels.
It actually wouldn't, because there have been two challenges to the NAFTA binational review panel so far, and the trade courts have both have decided to defer on political question doctrine to the fact that the president wants and has the lead on foreign relations. And that wouldn't be the case if the president withdrew. But I don't want to keep going back and forth. I just want to open it for the audience.
There'll be a pop quiz on all of this later, guys.
Yes. Questions? Professor Webster.
Thank you. Thanks for all of you, for a really stimulating panel. I really learned a lot. I wanted to follow up on a couple of things. I'm not sure if this is on. So first of all, if I understood you correctly, you said at the end that the U.S. does not face any credibility issues with regards to its withdrawal from any number of agreements. And I'm wondering if that sentiment is widely shared among panelists. When we look at the last 20 months, we see snubbing of the Human Rights Council, we see the withdrawal from TPP, even though that is still going forward among the 11 Pacific nations. We look at Paris Accord, we look at TTIP, we look at the possible also apply to existing agreements? And I'll leave that to
Let me just clarify my statement about credibility. I don't think I'd ever say about anything. I don't think I would suggest that that exiting agreements would not create any credibility problems as to any agreements. So what I specifically want to suggest is that exiting the Paris, first of all, exiting any international agreement pursuant to its terms should not raise any credibility considerations. That I'm prepared to say broadly, because part of the terms of an international agreement are its substantive terms and its procedural terms. And if a treaty permits for exit according to a particular procedure, implementing that is actually demonstrating an adherence to and taking international law seriously. It's just making a policy choice that you don't want to be part of the substantive set of commitments, but it is not in any way a rejection of international legalism. It indeed is pursuant to international legalism. In the particular case of the Paris Accord, because I believe it cannot, under domestic law, be appropriately accepted as an executive agreement, I would argue that the U.S. was never party and would not actually have to exit it according to its terms. However, that scenario is hypothetical because the Trump administration, while not taking a position on whether it was validly entered into as an executive agreement, decided to announce its notification of exit according to the terms of the agreement. So everyone knew this agreement has an exit mechanism, and that is the mechanism that is being used.
Your panelists share this.
Yeah, and I mean, look, I think that when you talk about treaties, right, and there's an exit process, I think what Eugene has said is exactly right, and there's more sort of oomph behind a treaty. When you have agreements like the Iran nuclear agreement, where everyone understood it was purely a political commitment, the parties even bothered to sign the document. The parties were aware of an upcoming election, and it was clear that the candidates on one side of the aisle were opposed to the agreement ardently. In fact, the reason why the president didn't submit it was clear he didn't have electoral majorities in either house. No one, from an economic analysis perspective, no one should be surprised, right, that the U.S. withdrew. And so there should be no reputational impact, notwithstanding the hand-wringing from our partners, right? The notion somehow that the United States was somehow not abiding by its international commitments. Everyone understood the weakness of the commitment the president was making, his inability to obtain electoral majorities in either house, his inability to obtain ratification, the fact that neither party would agree to sign the document, made clear to everyone involved that there was that the document itself was a thin reed. And so this concern that there's some massive reputational impact, I think, is at least from an economic perspective, completely at odds with the reality of what was done.
I would just like to differ with that only to the extent that I travel around the world all the time, and questions like you raise, which is what would happen to the U.S. credibility, and you're raising the international law principle of good faith. I put all of those in a folder I have by my desk, which is entitled Locking the Barn Door After the Horse Has Already Escaped.
You know, there's much more to international relations than legal formalism. There's questions of good faith, and that's an important factor in international relations. And the view in Canada is different from some of the other panelists' views about the perception of the United States as a reliable trading partner. I can tell you, and this is a political issue, it's not a legal issue, that U.S. reliability as a good faith trading partner has been eroded substantially in my country. And as I said, that's a question of perception and politics, but that is a vital part of international relations.
Let me just clarify what I said a moment ago, which was meant to be jocular, although my humor doesn't always work. This is a president who felt himself to have been elected by a constituency in the United States that wanted him to unravel a global order that they felt was detrimental to their own interests. And this is a president who concurred wholeheartedly in that. And I think it should be understood internationally that that's what he's doing. Lots of us may think this is really, really horrible. Lots of us concur with the sentiments in the New York Times editorial by the fellow who said, I'm working in the White House and I'm trying to prevent that. Lots of us concur with Gary Cohn saying, I went into the office of the president and I snuck the document off his table that he would have signed withdrawing from the Korea-U.S. Free Trade Agreement. We'd say huzzah to that, things like that. But it is where this administration is. And it's something we all have to think about, what its implications are for us, whether we are U.S. citizens or whether we are citizens of the world, or whether we are, as Theresa May put it, citizens of nowhere.
Well, with that comment, I would like to get at least one question from the audience, one question from a non-case professor or...
Students. Students.
Or a student, yes, Mr. Dowell.
Jumping off on this question of good faith, which I think is a very, thank you, Professor Webster, for raising it. I think Professor concur with it, but I think what you're getting at, though, is that, fine, good faith has political ramifications, good faith has these intellectual ramifications, or perhaps these moral ramifications, but it strikes me, if we had a prime, and I apologize for being political, but Larry, you opened the door, right? We had an administration who entered into these international agreements that they probably should not have entered into, or at least they were presented as these international agreements that had significantly more binding force, significantly more domestic constitutional authority than they actually had. And so we have this gap between reality and perception. And so I'm wondering if the current gap between, this current credibility gap that we seem to have some disagreement on the panel about, I mean, is that not a direct result of the gap between reality and perception that we had, for the last decade, let's say, if not longer?
Anybody want to take
I want to say it's a consequence. I want to say two things about good faith. It's a consequence in part of political surprise. Obviously, the Obama administration undertook these commitments in a thin way, on the expectation or reliance that a successor would continue them, and then these questions about exit or termination would never arise. But I want to turn Professor Webster's good faith point around, and I want to say there's potentially, you could look at good faith the opposite way. I think we see a recurring theme in withdrawal from international schemes, treaties, organizations, etc., where there's an international organization which is in no way supposed to be like the Hotel California in its description or design. So, and that's how you get people in. Imagine if the European Union, when it was being created, hung a sign on the door, Hotel California, you can enter, but you can never leave. Imagine if the United Nations Human Rights Council said, once you walk in these doors and once you send your first check, that's it. It's like canceling a Wall Street Journal online subscription. It's impossible. Then they would presumably get lots fewer members. If the Paris Climate Accord said no exit, there'd be less entry. So on one hand, there is this inducement to enter, and then a reversal, a turnaround when countries may wish to exit, saying, oh, no, this is forever, you're not allowed to leave, it's bad. And I think there's a certain almost bad faith in that, because it is potentially, what do you call it, procures entry on perhaps inaccurate terms.
I'm sorry, I can't let that stand. I'm sorry, I can't do this. It is, whether you talk, I'll be very brief. When you talk of bad faith, let's not put it in that context. You are talking on some of these things, and I put the United Nations and I put the World Trade Organization in this. World regimes, world concepts that have been established and led by the United States ever since the immediate post-World War II era. And the idea of saying, well, hey, this is something that we can in some way lightly and in good faith dismantle is something that treats those less seriously, it seems to me, than they should.
Well, but why would that be so? If there is an exit mechanism built into the agreement, you agreed to a deal, and there's a method for exiting, somehow when you exit, you've done so in bad faith under the terms? That any contract, any first-year contract students,
I fundamentally
any
disagree with what
first-year
you're saying.
contract student should understand that when you bargain for an agreement, and that bargain for that contract involves an exit provision, the idea that somehow you utilize exit provision is a bad faith activity it simply is inconsistent with law. And I understand that we're in the realm of politics here, and that maybe that's a discussion, and formalism might be empty, but let's be real, we're at a law school, it's about formalism.
That's
All right.
why first-year contract students don't run governments.
Oh,
If we're going to talk about credibility,
wait.
we should also just put on the table the credibility loss that you suffer when you set a red line and don't enforce it.
Absolutely. Let's continue the discussion, the heated discussion, even during lunch. This was a phenomenal panel. Let's thank our panelists for such a great work.